Hello, everybody. It's Yoli Medina. So today I'm going to be talking about the Kohberger case. And there was a lot of documents filed, and it's just a sea of sealed documents. And for those of you who may not be following the case as closely as people out there are following it, I just wanted to give you an example of what the docket looks like. Let me show you. So here's a docket. And as you can see, basically, there's a lot of order sealing state's objection, order sealing exhibits to state's objection, and just order sealing everything. However, there is one filing on January 13th, 2025, that is a motion to unseal the IGG suppression briefing and hearing, and that's the investigative genealogy or investigative genetic genealogy issue that's involved in this case. So here's the question I have is these orders sealing everything, they're based on stipulations. It says, see, like 1/7/2025, stipulated motion to seal state's amended expert disclosure. So they're based on the parties agreeing to stipulate that the information will be sealed, and then the judge signs an order. So the fact that the defense is now wanting to have a motion to unseal the IGG suppression briefing and hearing, you would think that it could be a stipulation to unseal it. I mean, at least I would think, unless the defense unless the prosecution is not willing to have it unsealed. And I don't know the answer to that. But in any event, there is a motion to unseal the IGG suppression briefing and hearing, and that motion is brought by the defense. So it's kind of strange because it kind of begs the question, well, why couldn't you just stipulate to unseal the IGG suppression briefing and hearing? So that's a question. So if anybody has followed this case, it's behind some kind of wall. And again, there's probably a good reason why, but it still creates a lot of intrigue. So what I do want to talk about also is the burden of proof. And so all of these sealed documents presumably have allegedly have evidence against Kohberger, or maybe it's evidence that is exculpatory to Brian Kohberger. But whatever the case may be, when the jury comes to hear the case, they're going to be presented with a jury instruction. And I just wanted to show the jury, I wanted to read the jury instruction regarding the burden of proof and the presumption of innocence, because sometimes I forget about that. And I know a lot of people might forget about it too. But let me show you that jury instruction. And here it is. This is Idaho jury instruction 103, reasonable doubt. Presumption of innocence, reasonable doubt. So I wanted to read it because this is the law. This is what our Constitution affords every defendant. And a lot of times I forget it. So I'm just going to read it. It says, under our law and system of justice, the defendant is presumed to be innocent. And again, I want to emphasize that's under our law and system of justice. That's the United States. So the defendant is presumed to be innocent. So the presumption of innocence means two things. First, the state, that's Idaho, has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant, in this case would be Brian Kohberger, is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crime beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If, after considering all the evidence, you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. So everybody who comes into the courtroom who is going to be a potential juror has to promise that they will presume the defendant to be innocent. So anybody who believes that the defendant is guilty, they are not going to be a juror. So I wanted to read that instruction because it is the law in the United States. And in the comment section, I'll read that. It says, the due process clause of the 14th Amendment requires that the jury be instructed on the presumption of innocence. So that is the due process clause of the 14th Amendment. It requires that the judge instruct the jury on the presumption of innocence. And it cites a case, Taylor v. Kentucky, 43-6 U.S. 478, 1977. Although technically not a presumption, the presumption of innocence is a way of describing the prosecution's duty both to produce evidence of guilt and to convince the jury beyond a reasonable doubt. The beyond a reasonable doubt standard is a requirement of due process, but the Constitution neither prohibits trial courts from defining reasonable doubt nor requires them to do so as a matter of course. Indeed, so long as the court instructs the jury on the necessity that the defendant's guilt be proved beyond a reasonable doubt, the Constitution does not require that any particular form of words be used in advising the jury of the government's burden of proof. Rather, taken as a whole, the instructions must correctly convey the concept of reasonable doubt to the jury. And they cite a case, Victor v. Nebraska, 511 U.S. 1-5-1994. And then it says, the above instruction reflects the view that it is preferable to instruct the jury on the meaning of proof beyond a reasonable doubt. This instruction defines that term concisely while avoiding the pitfalls arising from some other attempt to define this concept. Okay, so that is what the jury is going to be instructed on. And for those who forget that the defendant is allowed the presumption of innocence, this is just a reminder. And it's a reminder for me too, because Brian Kohberger isn't the only case that I follow. There are other cases where there are defendants, and sometimes I may be critical of the alleged defendant who allegedly committed the crime. But I too have to be reminded that they deserve a presumption of innocence. And so this video is just a reminder for me and for anybody else who might forget and might be critical and might have some thoughts in their mind about a particular defendant, that every defendant who's accused of a crime has the right to be presumed innocent. And that is the law. And no matter how much we can guess or speculate or believe we've proved the case, we are not the ones who are proving the case. It's the prosecution. They have the burden. And right now, that burden is sealed, meaning they may have a bunch of evidence, but it's sealed. And it's interesting that it was the defense who originally wanted the information sealed. I know that. And my criticism about lack of transparency is not solely directed at the government. I understand that it was a stipulation. The defense wanted it. For whatever reason, they wanted it. Private information, who knows why they wanted it, but they wanted it initially, and the state agreed. But then it came to a point where the defense in the Kohberger case wanted certain things unsealed. And the prosecution either doesn't want to agree to that, and therefore there's motions to unseal certain things, which is odd to me. So I will go over the motion to unseal the investigative genetic genealogy motion, or I'll go over that motion. But in the meantime, I just wanted to put that out there that yes, that the law, the Constitution allows for a defendant to be presumed innocent. And I need to be reminded of that as well when I'm talking about cases other than the Kohberger case. Because after all, we're human. We have opinions, we have thoughts, and nobody can blame us for that. But we all need to be reminded of the fact that we are not the people who are solving and judging the case, especially when the evidence, the burden, is sealed. The state's burden, whatever they may have, is under seal. There's just seals all over the place. So with that said, I'll call it a night, and I'll talk to you guys later in the next video.